I'm Stephanie Sass, patient advocate for Visiting Nurse Association's Breast Cancer Patient Assistance Program. For more than 120 years, VNA has provided expert and compassionate care to all those who need it, regardless of their age, station in life, or available resources. VNA is dedicated to shaping tomorrow's care today. We help build a stronger, healthier community through innovative in-home medical and non-medical care and community care programs. One of our most important community care programs is the Breast Cancer Patient Assistance Program, which provides financial assistance, system navigation, and emotional support to help alleviate stress for breast cancer patients, helping them focus on healing and recovery.
Hi, I'm Ann Mangiamelli, the Managing Attorney of the Health, Education, and Law, or HELP, project at Legal Aid of Nebraska. For more than 50 years, Legal Aid of Nebraska has provided dignity, hope, self-sufficiency, and justice through quality civil legal aid. We deliver innovative, specialized programs in order to strengthen the community and aid those who have been pushed to the margins of self-sufficiency. The Health, Education, and Law Project is a unique collaboration between Legal Aid of Nebraska and hospitals and federally qualified health centers in both Lincoln and Omaha, Nebraska. Help attorneys eliminate legal barriers that impact patients' access to health care and promote better health outcomes. With a shared mission in strengthening the community and aiding those struggling with self-sufficiency, VNA and Legal Aid of Nebraska have partnered for several years to expand resources available to breast cancer patients. As part of VNA and Legal Aid's ongoing partnership, we have created this set of video resources to assist breast cancer patients in navigating legal issues that may arise with their diagnosis and inhibit their access or ability to comply with treatment. These initial 3 videos cover topics of supplemental security income, Social Security disability insurance, powers of attorney and healthcare powers of attorney, employment benefit, and employee rights. SSI is supplemental security income, and it is based on a person not having worked, but how many assets they have and how much income they make. They can't make over $735 a month in order to qualify for SSI. SSDI, which is supplemental security income, is based on a person's work history. So if you have worked the appropriate amount of work credits over the last 10 years, then you will be able to qualify for SSDI. The amount of money that you will make under SSDI will be based upon how much money you have paid in. So clearly somebody who's worked part-time and hasn't paid in as much money will make less money under SSDI per month than the person who, say, is a doctor and has paid in a lot more money. SSI, everyone who qualifies under that program, the maximum amount that they can get per month is $735 as of 2017. That amount changes per year. If you qualify for SSI, as long as you qualify for that program, you automatically will qualify for Medicaid in the state of Nebraska. SSDI, Medicaid, you will qualify depending upon how much money you're getting paid under the SSDI program, as there's a need threshold for Medicaid as well. Disability determined under both SSI and SSDI under the same 5 steps. It's a 5-step approach. The first question that SSA, or Social Security Administration, is going to ask is, are you making substantial gainful activity? What substantial gainful activity means is, are you working and making over a certain dollar amount per month? That dollar amount changes every year. Right now, I believe it's $1,170. I usually will tell people if you're making over $1,000 a month, you're not going to get that step. Even if you're disabled, if you are still working and making over $1,170 or SGA, Social Security cannot find you disabled under the law. It's the biggest problem that I have with people who are trying to get disability is they continue to work and they will apply and they get turned down because they're working over that amount. The second step is, do you have a severe impairment? Do you have an impairment that affects your daily activities of living to an extent that Social Security is going to consider it severe? The third step is, do you meet what Social Security calls their listings? If you look on the internet, there is a specific list of items that if you qualify or actually have one of those illnesses, you are automatically determined to be disabled under Social Security's rules. They're a very high bar, so they're hard to meet. The fourth step is, if you don't meet one of those listings, are you able to go back to your original job? Do the impairments that you have get in the way enough where you can't go back to that job? If Social Security determines that you cannot go back to that job, the fifth step is, can you do any other job in the national economy? So could you be a ticket taker at a theater, or could you work at a fast food restaurant? They actually look to determine, are there any other jobs that you can do? If all of those steps are met and you can't do any other job in the national economy, that's how they determine you are disabled. There's several reasons that I have found that people who have cancer get denied disability. The first one is on duration. So in order to be found disabled, Social Security has to determine that your illness is either going to result in death or last at least 12 months. With cancer, a lot of times the treatment does not last 12 months. So Social Security will determine that the person is not disabled because they're going to get better before that 12-month period of time. What they fail to take into account is sometimes chemo will have a long-term effect on people, and so they really will meet what we call the durational requirement of 12 months. The second reason that I find that they get turned down is that they don't fill out the questionnaires correctly. You will get a questionnaire from Social Security that says, what are your daily activities and what are you no longer able to do? And Social Security will compare those documents. They're long and they're arduous to fill out, and sometimes people won't fill them out correctly, and they will get denied just on the fact that they haven't filled those out so that Social Security can make a proper determination. The third reason that they get denied is they pick the wrong, what Social Security calls onset date. What day did you last feel you could no longer work? Because they pick a day where they still are working and making SGA, they will get denied on that reason, and Social Security won't explain to them that if they pick a later date when they've actually stopped working, that they may actually meet the Social Security disability requirement. That's why I always recommend that people at least talk to a disability attorney to get advice when they're filing that initial application. So can you work while you're applying for disability, or can you work once you get disability is kind of a two-part question. Yes, you can. As I explained earlier, Social Security, that first question they're going to ask is, are you making substantial gainful activity? That really means, can you work a full-time, 5-day-a-week job? If you can't, but you're working part-time, so say you're working 20 hours a week and you're making $500 a month, you're still considered disabled under Social Security's rules. So yes, you can work some and still be considered disabled. Now, Social Security will look at what kind of job you're doing currently and determine whether they think you could work that full-time. But that doesn't mean that it's going to inhibit you from getting found disabled. Secondly, once you get disability, you can continue to work or you can go back to work. Social Security has what's called the Ticket to Work program, where they actually will work with individuals that are on disability to try to work with them to get them back into employment roles. You can work for a period of time without your benefits being cut. And that is to work you back into a time where you can get off of disability and go back into the work. The difference between a healthcare power of attorney and a durable power of attorney. A healthcare power of attorney appoints somebody to be your agent to make healthcare decisions if you are not in a situation where you can make your own healthcare decisions. In other words, you've been found to be incapacitated and unable to make medical decisions. A durable power of attorney is a financial power of attorney that allows somebody to basically be you so that they can write checks, pay your mortgage. We do these for individuals, especially when they're in the hospital, so somebody can take care of their financial things while they're being treated in the hospital. A big difference is the healthcare power of attorney only takes effect when somebody has been found to lack capacity. The financial power of attorney kicks in the moment that it is signed. There are certain instances where you can change that, but for the most part, it is available the moment that someone signs it. People often use those interchangeably, and they're actually two different things. A healthcare power of attorney, as I said, is so that you appoint somebody as your agent to make medical decisions for you if you can't make your own medical decisions. A living will sets forth what you want the doctors to do if you are in a persistent vegetative state and expected not to regain consciousness. So rather than appointing somebody to make those medical decisions for you, it actually gives instructions to the physicians that if you are in that state, what they would like the physicians to do on your behalf. Now, a living will and a power of attorney for health care can interact in that the power of attorney, the person that's appointed as your agent, can use the living will as a guide as to what decisions you would want made if you were able to make your own decisions. When you sign a power of attorney, does it take away your right to make medical decisions? It does not. As I stated earlier, it is something that only takes effect when two physicians have determined that you lack the capacity to make your own medical decisions. Once you regain capacity, your rights come right back. It really just lets somebody step in for you when the doctors have determined that you can't make those decisions on your own behalf. But the minute you can, you're able to step back in. The other thing is, until a court of law has determined that you are incompetent, even if the medical doctors determine that you lack capacity, and those are two different terms, you actually have the right to revoke your healthcare power of attorney and not have somebody else make your own medical decisions. The hospital still may not let you make your own medical decisions, but it would then take away that other person's right to do so on your behalf. FMLA is a Family Medical Leave Act, so you have to have within a period of 12 months worked 1,250 hours for an employer. The employers that qualify that have to go by FMLA have 50 employees or more within a 75-mile radius. So very small businesses do not have to go by FMLA. The Family Medical Leave Act allows you to have up to 12 weeks of unpaid leave for things such as the birth of a child, a major illness of yourself, a major illness of a family member. What people should know is you don't have to take FMLA leave all at once. So if you are being treated for cancer and you can work part-time, but then you have to take some time off to go have chemo treatments and then you're ill for a couple days after that, you can actually take the FMLA days at a time up to that 12 weeks. And I think people often mistakenly think that you have to take all 12 weeks at a time. So it's very helpful to cancer patients because they can take it as they're being treated for cancer. People often ask whether they can be asked to use their vacation and sick time while they're on FMLA. FMLA is an unpaid leave, but employers can ask you to use your vacation and sick leave if it's in their policies, if it's within the policies of that particular business. So yes, you can be asked to take your vacation and sick leave and use that up as part of the FMLA. It does not add to your FMLA. And I think that's the question that people are always asking is, I have 4 weeks of vacation, plus I should get 12 weeks of FMLA. Doesn't that then give me 16 weeks? And it doesn't. If they ask you to take vacation as part of the FMLA, you'll have 4 weeks of the FMLA that is paid leave, but unfortunately you still only get 12 weeks of FMLA leave. I often get calls from people who are still ill after 12 weeks and they don't think they can return to work, and they ask what happens at their employer once they can't go back after the 12 weeks. Unfortunately, they never like my answer, which is you can actually be terminated from your employment if you can't return after the 12 weeks. The FMLA is meant to be a balancing act between the rights of the employee to be ill and take care of themselves, but also not to be an undue burden on the employer. So not to have a person who's going to be gone for an extended period of time and not coming back. So unfortunately, the employer can terminate you if you are unable to return after 12 weeks. The ADA and the FMLA, the American with Disabilities Act, they kind of interact with each other. The ADA, in order for an employer to qualify for that, they only have to have 15 employees. And as long as they can accommodate the employee without it being an undue burden, and that's kind of a wide term and one that the employer has to figure out, as long as the employer can accommodate you without it being an undue burden, then they are required to accommodate you to return to work if you are considered disabled, and not a Social Security disability, but a disability that it's a different level of disability. If you are still considered disabled and you specifically ask for an accommodation, they're required to accommodate you as long as it's not an undue burden to them. Something I'll give as an example is you have to miss a couple hours a week for work to be able to go to a chemo appointment, for instance. That would not normally be an undue burden on an employer, and they should be able to accommodate those hours. Also, changing you from heavy lifting work to light work. That is something that's considered a reasonable accommodation under the American with Disabilities Act. So even if under FMLA you're still getting treated, it is possible to ask for a reasonable accommodation under the American with Disabilities Act and return to work.
We hope you find these videos to be a valuable resource for you and your loved ones. We are so very grateful to the Bellevue Chapter of the Fraternal Order of Eagles for generously funding this project.